Hello everyone, this is Tom Fox and I'd like to welcome you to This Week in FCPA for the week ending August 26, 2016. This is episode 19, the International Edition. As always, I'm joined by my co-host, Jay Rosen. Jay is on location in Hawaii and I'm in location in Oxford, England for this special episode of This Week in FCPA. Even though we are quite geographically separated, we have quite an interesting show for you this week. We talk about the post in the FCPA blog about the speech by John Kerry that corruption is a root cause of terrorism. We use that to discuss the role of businesses in fighting corruption, and most particularly the role of the FCPA and a best practices compliance program. This leads into a post I put up today, Friday, August 26th, on lessons from history for your compliance program from the Tudors, specifically Henry VIII, and the FCPA Compliance Report. I'm also in the middle of a 2-week review of the 10 hallmarks of an effective compliance program. This week we had hallmarks 1 through 5. I've got blog posts on each hallmark and a podcast on each hallmark. You can check those out at the FCPA, www.fcpacompliancereport.com. We also discuss 2 other interesting and apparently now related topics. The first was an op-ed piece by Eric Ben-Artzi last week in the Financial Times, which explained why he turned down his SEC Whistleblower Award. And Jay talks about the post in the FCPA blog by Paul Pelletier around the FedEx trial debacle for the Department of Justice and Pelletier's recommendation to fix a recent spate of ill-fated and DOJ prosecutions. These 2 pieces tie in nicely to some of the issues raised, the Artzi Op-Ed piece and the Pelletier piece found in the FCPA blog about not only the revolving door between government and private industry, but also how cases are vetted at local DOJ offices and appropriate level of review and oversight. So we hope we have a very interesting episode for you today. I'd like to thank you for listening to This Week in the FCPA. Hello everyone, this is Tom Fox and I would like to welcome you to a special international edition of This Week in FCPA. I am in Oxford, England for this recording, and Jay, it is nighttime and I'd say it's about low 60s, high 50s today. Where are you and what is your condition?
My condition is truly relaxed, coming to you from Lahaina, Maui. It is kissing up here about 10 a.m. in the morning. And Mrs. Translations and the M&Ms are out shopping on the beach, so they would make you proud, Tom. And I'm going to try to get a little bit excited, but I'm just too much in my Maui chill. But this week in the FCPA still goes on.
Indeed it does. Indeed it does. So I am on a 2-week summer study at Oxford, and I am studying the Tudors. We were just about to conclude our first week of study as we record this. So we're going to see how Henry VIII, and some of the historical record around him might help inform your compliance program. But first, we wanted to start with something a little more contemporaneous to the 21st century. And that is a talk given by John Kerry, as reported in the FCPA blog, that he made this week in Nigeria. And it was really a talk about corruption as being one of the root causes of terrorism. And he, of course, talked about the fight against corruption in Africa with Boko Haram, and really had some fairly stunning statistics, I thought, Jay. He said that graft costs the global economy an estimated $2.6 trillion every year, which he correctly pointed out could be going towards infrastructure, healthcare, education, food security, or other initiatives, all things that give young people a sense of hope and a sense of the future. What he linked was governmental corruption, not leading to such direct criminal acts as guns being smuggled across a border, or people being able to infiltrate the United States, as was alleged in 9/11, or alleged around 9/11, but that corruption also leads to terrorism by taking away people's hope. And when they have no hope, they tend to turn to, or at least in some places have turned to, things like terrorism. So I thought that was a really interesting way to look at corruption, and really pointing out why it's in the interests of the United States government to continue to fight corruption. And the most potent tool we have in that fight against corruption is the Foreign Corrupt Practices Act. So for those who want to amend or lessen or reduce the FCPA or its enforcement, I think this very powerful speech by John Kerry really points why it is not in the interest of the United States to do so. So,
Yeah,
what were your
I
thoughts?
totally agree, Tom. One of the things that stood out for me, and this is a quote from Secretary of State Kerry: bribery, fraud, and other forms of venality endanger everything that we hold dear, everything that we value. So again, to talk about that root cause, that if people do not have any faith in the government, if they don't think they're going to get a fair deal, as you just eloquently said, they're going to be susceptible to other corruptive, ideologies who might say that if you go with us, we will get you a better deal. And that really allows the birth of all these different terrorist organizations that are springing up around the world. And a lot of it is, as you said, based on the hopelessness of the local population.
So, of course, the FCPA-J is a supply-side law focusing only on the conduct of the bribe payor, not the bribe receiver. And admittedly, there may be less potent tools for the U.S. government's fight against the bribe receivers if they are outside the United States. Nevertheless, I find the FCPA to be an important component of this fight against not only corruption, but terrorism, as articulated by Secretary of State Kerry. And it really points out to me, in thinking through it, the responsibility of everyone in the fight against corruption, from people who might spot, to businesses who are now by law prohibited from engaging in bribery and corruption outside the United States under the FCPA, and their responses to such mundane acts as putting together best practices, compliance programs, and procedures. So I really see it as a unidimensional continuum, and it was really interesting that Secretary Kerry pointed out this pretty clear connection, and it was featured in the FCPA blog in something that's typically apolitical. Nevertheless, I found it a very good articulation.
Agreed. So, Tom, next I think we will again take a look at something that's FCPA related, that goes to the world stage, and there's been several articles over the last couple weeks in the British press. This one that we're going to talk about is from the Financial Times, and it's really interesting that there's an interview with Eric Ben-Artzi, who is a former employee of Deutsche Bank in London. He was a whistleblower, and he has decided that he does not want his share of the monies awarded to him based on being a whistleblower on Deutsche Bank, and he would have netted over $3 million. And this, I know you're going to go into the weeds in a second, but I think this really makes Mr. Ben-Artzi a double whistleblower, because not only did he whistleblow on what was happening within the Deutsche Bank organization with some mirror trades going on in Russia, but he really is shining the spotlight on some of the players who used to work for the bank and now are regulators for the U.S. government. So I think that's an appropriate point for you to jump in.
Well, I think he was actually in New York when he blew the whistle, not London, which really puts it clearly in the jurisdiction of the United States. Nevertheless, there were two parts to his critique, and he wrote an op-ed piece for the FT entitled "I Turned Down a Whistleblower Award." We must protect shareholders from executive wrongdoing. And as a former Deutsche Bank employee, he was troubled by the back-to-back trades that you referenced, and he was even more troubled that the fine and penalty was against the bank, meaning against the shareholders of the bank, and that would be paid basically by the shareholders of the bank, although some of it may have been, didn't reference in the article, some of them may have been paid by insurance coverage. Nevertheless, the overall point is that no one at the bank was punished. And he found this more than anomalous. He found this troubling. And indeed, he said that top executives retired with million-dollar bonuses based upon the misrepresentation of the bank's balance sheet at the time of the incident in question. And he contrasted that with another SEC enforcement action against a smaller company, Trinity Capital, where the SEC went after the actual executives of Trinity and had litigation against two senior officials. So there was really, in his mind, no holding of Deutsche executives to task for their, if not overall tone, certainly, or excuse me, if not direct involvement, then their overall tone to allow the illegal activity to continue. He also had another critique about the what he called the revolving door. And he specifically pointed to Robert Rice, the chief lawyer in charge of internal investigations at Deutsche Bank, went to become the chief counsel for the SEC in 2013, and that Robert Guzami, Deutsche's top lawyer in America, became the head of the SEC's enforcement division after the financial crisis. And to kind of round out the triumvirate, he said their boss, Richard Walker, the bank's longtime general counsel, was once head of enforcement at the SEC. And he felt that this revolving door had led to a settlement that didn't really go after any of the high-ranking individuals at Deutsche Bank.
So somewhat of a sweetheart deal, you might say?
Well, that was certainly his perspective.
Yeah. So I think this, this revelation bears watching over the successive weeks. We're coming up in the conference season, so it'll be interesting to see if there are any, if the SEC tries to get ahead of this, or what kind of comment they have. And then I guess it really all goes back under the watch of Mary Jo White, who is the current chair of the SEC. So,
well, actually, you were going to tie this, I think, to another article that really drew your interest this past week.
Yeah. So again, we're going to go to our good friends at the FCPA Blog, and there is an article today written by our friend Paul Pelletier, who's over at Pepper Hamilton. He has a long background having worked at the DOJ, and he takes a look at the failed FedEx prosecution for drug trafficking, and where he finds, what happened was this has been a case that the DOJ had been pursuing for a while. On day 2 of the trial, they copped to the fact that they didn't have conclusive evidence to tie the charges to FedEx, and they let this go away. And Mr. Pelletier's assertion is that there's been a huge talent drain that's happened over at Main Justice over the past few years, and not so much the issue of the revolving door, but that many of the people who would lead these investigations have now left to go to private practice. And there will be a post-mortem that's going to be done on this matter, and Mr. Pelletier's hope is that with increased training, supervision, and review, that they'll be able to build up the skill set of those current prosecutors who are at the DOJ and the SEC. And, hopefully this debacle with the FedEx trial will not get pinned on a couple junior people, but they really will take this as an opportunity to take a look at what needs to be done to, again, take care of this talent drain. So in one sense, and what we're looking at with the Deutsche Bank thing, we're looking at a very cozy relationship between former in-house counsel and former regulators. And now we're looking again at a situation where the government probably spent a lot of our taxpayer dollars proceeding and preparing for this trial with FedEx. And if this was done properly the first time, maybe there would have been a different result, and we do not have DOJ again having run an unsuccessful trial against either individual defendants or a large corporation defendant.
I was interested in Pelletier's article because he talked about it from a fairly high strategic level. Mike Volkov has written about this trial as well, and Mike looked at it from a bit more of a tactical level, where he explained the mistakes, or rather I should say he critiqued the actions by the DOJ prosecutors, and the relationship between the Department of Justice and FedEx is one of close cooperation, as you might guess, in a wide variety of areas, as FedEx is generally viewed as a trusted partner for importation of goods into the United States, and that information that the Department of Justice may develop through their cooperation or FedEx's cooperation with the DOJ may have been at one of the bases for the prosecution. But both Pelletier and Volkov were quite critical of the specific claims that were brought against FedEx, and really I think those criticisms of those claims really lend or lead more into Pelletier's critique that there needs to be some more senior level oversight. And if you're going to bring one of these cases, there really needs to be some type of senior level oversight, whether that be in a local office, whether that be in main justice, how you get lawyers trained and have a talent pool of well-trained, well-seasoned lawyers is an ongoing debate and question in corporate America and law firms, and certainly in the government as well. And with the pay disparity between corporate America, private firms, and government, it's going to be very hard, I think, for the government to compete with many of these other avenues that are open to lawyers from the Department of Justice. But you've got to have a way to have seasoned lawyers looking at it, reviewing it. If you're going to bring criminal charges, I think there should be an appropriate level of oversight and review. And I agree with Paul Pelletier that I hope the postmortem will truly be a root cause analysis, and they won't just pin it on some tactical decisions made by lawyers on the ground. If those tactical decisions were either erroneous or should not have been made, I think that speaks to Pelletier's point that there really needs to be an appropriate level of appropriate senior level review, whether that's senior in the specific district, whether that's senior at main justice, whether it's senior somewhere else in the Justice Department. I don't know because I'm not an ex-DOJer, but I think his point is very well taken that this was a huge debacle and very public debacle. And when you have such a public debacle, you need to have a public response, and part of that response would be an appropriate after-action report, post-mortem, or root cause analysis.
So a question on the rules, Tom. When somebody does leave the government and go into private practice, I'm not recalling the proper term, but from my perspective, I would say they basically have a non-compete. So is there a specific either list of a case, or is there a time in which they cannot be involved with appearing in front of the DOJ representing their new private clients?
Yes. So if it's a non-political appointee, they have a 2-year ban on negotiating or representing clients in front of the government. So if somebody from the FCPA unit came out, Pat Knowles came out or joined a firm whose name escapes me this summer. He's got a 2-year window where he cannot represent corporations in front of the government. And however, if it's a political appointee, there's a 5-year ban. So I think there's an appropriate time period in place. I'm not concerned about as much about that as some of the other issues that Paul Pelletier raises in his piece as well. So I think I like your observation that with the upcoming conference circuit for the fall, it's going to be interesting to see what the dialogue is, from corporate America, from law firms, and from others. And as we lead through the fall, there'll be many, I think SEC and DOJ are speaking at some of these conferences. And that may be one of the series of questions they're posed. Whether they can answer them at this point, probably not. But I think it's going to be certainly a dialogue this fall going forward.
Yeah. Well, part of our theme of of our discussions, for the last 3 or 4 months has been the amount of information that's out there from the FCPA, rather on the FCPA from DOJ and SEC, and they are doing a better job articulating what they need in terms of ethics and compliance programs. And I think this would be a nice little place to kind of jump off and catch everybody up. Blog talking about the 10 hallmarks of ethics and compliance program. So
well, before we do, I completely mumbled up Pat's. It's Pat Stokes, and he's at Gibson Dunn. So sorry about that, Pat. It's he's the former head of the FCPA unit to leave. But yes, so Jay, as you knew and know, I am on a 2-week summer study program in Oxford studying the Tudors. And we went through the first week. We actually started pre-Tudor with the last Plantagenet king, Richard III, from the House of York. And now we're up through Henry VIII. And one of the things that struck me is how the events around Henry's split with Rome, the dissolution of the Catholic Church in England, and the dissolution of the monasteries and other church properties in England really helped inform my view of a best practices compliance program. In conjunction with this 2-week summer study, I put together a 2-week 10-piece blog and podcast series on the 10 hallmarks of an effective compliance program, and I'm through the first 5. But one of the things that we talked about in our class was the steps that led Henry to declare himself, first of all, as the head of the church in England. That's really separate and apart from his dissolution of church property. Those were really 2 separate steps, and they were really 2 separate acts. But even within the context of those 2 steps, the question we've been debating is, was there some overarching or overreaching plan in place, or was Henry and his advisor, specifically Thomas Cromwell, reacting to events on the ground? And what I had sort of leaned that way, but I had not realized that apparently the Pope was prepared to grant Henry first a divorce and then an annulment. But that granting never came through, because what happened was the King of Spain, Charles V, invaded Italy for completely unrelated political reasons. And in the course of that invasion, he actually captured Rome and took the Pope prisoner. The significance of that to Henry and his attempts to divorce himself from Catherine of Aragon so he could marry Anne Boleyn was that Charles V was the uncle of Catherine of Aragon. And once the Pope was under the house arrest from Charles V, there was no chance that Henry was going to get either his divorce or his annulment. So it was that event which really led to Henry claiming or taking the title of the head of the Church of England. And as the head of the Church of England, he had the bishop had the right to grant him an annulment, and magically that happened. So I found that very interesting. But the second part was where Henry actually took over all the church property and made it property of the Crown of England. And the fallout there, of course, was he got some very valuable properties. He sold a lot of that property to other aristocrats, so he was able to garner a pretty big war chest to go back to battles with France. But the dissolution of the monasteries and the church property was in response to the original response to Henry declaring himself as the head of the English church. And that response was a uprising in something called the Pilgrimage of Grace. And that so enraged Henry that either he or his chief minister, Thomas Cromwell, then instituted laws dissolving and taking all of that property and making it property of the English crown. So what that led me to really think about, Jay, was how compliance programs need to have flexibility to respond to events on the ground. As your company changes, as your company may go into new markets, as it may develop new products, as it will enter certain geographic areas or certain new relationships, you have to have the ability for your compliance program to evolve. Additionally, if you have a 1-year compliance program, it's going to be different than a 3-year compliance program, and that's going to be different than a 5-year compliance program. At some point, you're going to need to do additional steps in your compliance program, such as auditing of your third parties. But you also may move to more efficient use of compliance, making it a more business process. But that doesn't happen when you design an initial compliance program. You've got to write a policy and procedure. And all of that's laid out in the 10 hallmarks of an effective compliance program. So the first 5 were tone at the top, hallmark number 1. Number 2 is your code of conduct, policies, and procedures. Number 3 is oversight, autonomy, and resources for the compliance function. Number 4 is risk assessments. And then number 5 is communication about your compliance program and training. And I lay out some of the basics in these podcasts and blog posts. It's all based on my book, Doing Compliance, which is available through Compliance Week if you want a more full explanation, and gives you a greater breadth and scope of understanding and things that you can implement. So I found it very interesting that from the historical perspective, it really appears Henry VIII did not intend to do what he did, but it was really in relation to a series of both religious and political obstacles that he ran up against. And in many ways, your compliance program is going to run up against new and different obstacles. The government is going to have new and different ways to look at things and to react, as we saw by this week with John Kerry's speech, tying it in nicely, I thought, that you can, if the U.S. government views corruption as a condition leading to terrorism, I think the U.S. government is going to use all of the tools at its disposal to fight corruption. And in the business world, that means the FCPA, and that means that you need to have a compliance program in place so that the government does come knock. First of all, so you protect yourself, and if the government does come knocking, you potentially can show them what you've done.
So I know none of us have any ugly children. You've done the first 5 hallmarks. If there was one blog that you wanted to direct people to, or since we're at the halfway point, what do you think stands out most about the first 5 that we've addressed, and what would be the most useful for somebody, just starting to design an ethics and compliance program from scratch?
Well, if you're going to start, it all starts with a risk assessment. And you've got to assess and the reason it starts there is if you don't measure it, you can't manage it. And the risk assessment is designed to identify your risks. The risks of Merrill Brink are going to be quite different than those of Exxon. And you, as Mr. Translations, may know those intuitively. But if you don't measure those in some demonstrable way, then you can't really graft an appropriate program to implement a risk management solution. And risk assessment is not a one-off or one-time document, but it does start. It's the first step in your program. You can risk assess at appropriate intervals going forward, probably every 2 to 3 years. You can have interim risk assessments to assess where you are. You can use risk assessments in a variety of other ways. If you go into a new market, if you have a new product, if you're doing an M&A deal, a variety of other ways. But the one thing, Jay, that I've come back to, and I come back to every company that gets into trouble, not only for the FCPA, but for fiddling with the books, getting in trouble with the SEC, for fraud, for accounting fraud, for market manipulation, it all starts with the top. If you've got crooks on the top, you're going to have crooks on the bottom. And even if you say the right things, I mean, Enron was the best example. They had the gold standard code of conduct, which they bandied about as the world's greatest energy company. Well, they had 2 convicted felons running the company. But if you don't have not only the appropriate tone, which is we're going to do business ethically and in compliance, saying that, but walking that walk besides talking the talk, you're not going to have really a chance at an effective compliance program, because employees are going to hear that, but they're going to see you model behavior, which pretty much makes clear that it's all about the numbers. So you got to have the right tone at the top. You got to have senior management buy-in, and you have to have senior management engagement.
Great. Thanks for clarifying that for some of the folks who are going to be looking at these topics for the first time, and always a good reminder for those compliance professionals. So Tom, next week you're still in England studying the Tudors, and I will be back on the mainland. Anything else for us to look forward to in terms of webcasts or other appearances coming up?
Well, next week I have Hallmarks 6 through 10, both blogs and podcasts. So that's kind of in the short term. But I wanted to ask you, will we be seeing your weekend report?
Yes, I of course need something to do on the 6-hour flight back to Los Angeles. So I'm going to do my best to assemble everything together. And I really think, as we've discussed over the last few minutes, that if we take a look at the Deutsche Bank whistleblower, and we take a look at the Paul Pelletier's article about FedEx, that it should really give some of our colleagues some food for thought. And as you said, hopefully we'll hear some answers in the coming weeks at the upcoming conferences. And so the short answer is yes, I will get that out. It'll probably post Friday night when I get back to the mainland.
Well, great. Well, enjoy your last couple of days with Mrs. Translations and the M&M girls. And I look forward to continuing the conversation next week on This Week in FCPA.
Cheerio.
Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to This Week in FCPA for the week ending August 26, 2016. If you'd like any more information on any of our topics, you can check out the show notes, which are accompanied to this podcast. This is Tom Fox. I'd like to thank you very much again for listening.